Imagine you vent online, maybe after a really tough day. You post some dark humor, or maybe even some rap lyrics expressing frustration. Then, kind of out of nowhere, you find yourself facing actual criminal charges for making what's called a true threat. How could that even happen, especially now, in our digital world?
It seems like a blurred line, doesn't it?
Totally. Welcome to the deep dive. Today, we're plunging into a really fascinating and honestly critical Supreme Court case that tackled exactly this question, Elonis v. United States. We're exploring that sort of murky legal line between protected free speech and, well, actual criminal threats, particularly when it comes to things people post on social media.
Right.
You've given us a great stack of sources. We've got the actual majority and dissenting opinions from the court itself, plus some really insightful expert analysis. So our mission today is basically to unpack these, pull out the most important bits, and help you understand this pretty complex legal landscape around true threats, mental intent, and how, yeah, your Facebook post could potentially cross paths with criminal law.
Yeah, hopefully leading to some aha moments for you about free speech online. It's a discussion that feels really relevant today, doesn't it? So much of how we talk happens online where, context and nuance just get lost so easily.
That's so true.
And what makes Solana so compelling is you see this like decades-old law running smack into a totally new way of communicating. It really forced the court to wrestle with these basic questions about what someone means when they type something out.
Okay, so let's dig into this. It really is a cautionary tale. Our story starts back in May 2010, Allentown, Pennsylvania. We've got Anthony Elonis, he's 27, working at an amusement park.
Right, and by all accounts, his life was kind of falling apart. His wife of 7 years had just left him, and she took their 2 young kids.
A really tough situation.
Yeah, and his response to all this upheaval was he started posting publicly on his Facebook page. He used this pseudonym, Tone Dougie, kind of adopting this rap persona.
Tone Dougie.
And he claimed these posts were, self-styled rap lyrics, that it was therapeutic for him. He even sometimes threw in disclaimers, like fictitious or no intentional resemblance to real persons.
Trying to cover his bases, maybe?
Seems like it. He even linked to the Wikipedia page on the First Amendment sometimes, almost like trying to build this preemptive shield,
But those disclaimers, they didn't really do much to soften the blow of the posts themselves, which, as our sources show, got really dark really fast.
Yeah.
Disturbing stuff.
Definitely. He aimed these violent threats directly at his estranged wife. Saying things like, "If I only knew then what I know now, I would have smothered your ass with a pillow, dumped your body in the back seat, dropped you off in Toad Creek, and made it look like a rape and murder."
Wow. That's incredibly specific and graphic.
And his wife confirmed she read it. She immediately went and got a restraining order against him.
Which you'd absolutely expect her to do.
But that didn't stop him, unfortunately. Just a week later, Elonis posted again something like, "Fold up your restraining order and put it in your pocket. Is it thick enough to stop a bullet?" And then he went on describing using explosives.
So it's not just venting anymore, it's escalating.
Exactly. It's hard to ignore how targeted it was and just how much the intensity was ramping up.
And then it got even worse, right? He got fired from his job at the amusement park.
Yeah, that was after he posted a picture of himself holding a knife to a female coworker's throat with the caption, "I wish."
Oh my goodness.
And after being fired, he posted more threats this time aimed at park visitors and other employees. And then, unbelievably, he posted about initiating the most heinous school shooting ever imagined in a kindergarten classroom.
That's just horrifying. It's crossed multiple lines by this point.
Absolutely.
Yeah.
And as you can imagine, this kind of thing drew the attention of federal authorities. An FBI agent actually visited Elonis at home.
And how did he react to that?
Well, afterwards, he posted about the little agent lady, saying he took all the strength I had not to turn the big ghost, pulled my knife, flicked my wrist, and slit her throat. He also claimed he was trapped with a bomb.
So threatening a federal agent now, too.
Yes. The escalating nature, how explicit it was, how targeted these messages were, it really made legal action seem pretty inevitable at that point.
Yeah, no kidding. So unsurprisingly, Elonis faced some pretty serious legal consequences.
He did. He was indicted, went to trial, and was found guilty on multiple counts of interstate communication of threats. That falls under 18 U.S. Code Section 875C.
Okay, what exactly is that law?
It's actually a law from back in 1939. Basically, it prohibits sending any communication across state lines that contains any threat to kidnap any person or any threat to injure the person of another.
A 1939 law applied to Facebook posts in 2010. That's quite a jump.
Exactly. And he appealed his conviction. His argument was essentially that he didn't actually mean to threaten anyone, that he didn't intend to carry out any of these acts. He kept comparing his posts to protected rap lyrics.
So his argument was all about his subjective intent, what was in his head versus how the words landed.
Precisely. He thought his own lack of intent should matter more than how other people perceived his words.
Okay, this brings us to the really crucial legal stuff. We all know the First Amendment protects free speech, but I mean, it's not unlimited, right? What kinds of speech are generally considered unprotected?
That's a really fundamental point. We often hear those classic examples, right? Like shouting fire in a crowded theater or using fighting words.
Yeah.
Those aren't protected because they cause immediate harm or, public disorder. And one specific category, which is absolutely key here, is true threats.
True threats. And the precedent for that category, it kind of came out of a Supreme Court case called Watts v. United States way back in
Or
66.
that's the one, yeah, the Watts case. It involved Robert Watts, who was an anti-draft activist. At a rally in 1966, he said something like, "If they ever make me carry a rifle, the first man I want to get in my sights is LBJ," meaning President Lyndon B. Johnson.
Okay, saying you want to shoot the president, that sounds like a threat.
It does, and he was charged. But the Supreme Court actually overturned his conviction pretty quickly. They called his statement political hyperbole, not a true threat, especially when you looked at the context of the rally.
Interesting. So Watts established this idea of a true threat, but it left a big question open, didn't it?
It did. Critically, it didn't really spell out what mental state, what level of willfulness or intent was needed for something to cross the line into being a true threat.
And that ambiguity, especially with new technology like social media popping up, is exactly why Elonis' case ended up going all the way to the Supreme Court decades later.
That's it, exactly. The court had to figure out, is it about what the speaker intended, or is it just about how a listener perceived it? And that gets super complicated when words are just text on a screen,
Yeah.
Without tone or body language.
Yeah, stripped of all that context. So that leads us right to the core issue for the Supreme Court in Elonis' case, whose intent really matters. At Elonis' trial, the judge told the jury they could find him guilty if, basically, an average person would believe his posts were intended as a threat. That's what lawyers call an objective standard, or a reasonable person standard.
But Elonis pushed back hard against that. He argued it was fundamentally unfair. Like, how could you convict him based on how some hypothetical reasonable person might read his words without proving he actually intended to threaten anyone?
He felt his actual thoughts, his subjective state of mind, had to matter.
Yeah, he basically said, it doesn't matter what he thinks, was precisely the problem with the jury instruction.
So the million-dollar question for the Supreme Court was, does that law, 18 U.S. Code Section 875C, require the prosecution to prove the defendant's subjective intent to threaten? Did Elonis actually have to mean it as a threat?
Or was that objective standard, would a reasonable person perceive it as a threat, enough?
This tension, subjective versus objective, it's huge in criminal law. It often boils down to different mental states, right?
Yeah.
Like purpose or knowledge or recklessness. Recklessness being when you kind of know there's a risk, but you ignore it.
Exactly. Or even just negligence, which is usually not enough for serious crimes. The court had to apply these really old, deep principles about criminal guilt to this brand new world of online talk.
Okay, let's get into what the court actually decided. Let's start with Chief Justice John Roberts' majority opinion. He basically said that the reasonable person standard wasn't enough here.
That's right. Writing for the majority, Roberts stated pretty clearly that a Facebook user could not be convicted just because one of their friends found a post threatening. He argued that for criminal liability under this specific statute, you need more than just general intent or that reasonable person view.
And why was that? What was the reasoning?
It's centered on this principle of conscious wrongdoing. Basically, the court generally doesn't like to just assume a reasonable person standard is enough for a criminal law unless Congress makes it super clear. It ties back to this fundamental idea in American law. Wrongdoing must be conscious to be criminal. Generally, you need to have a blameworthy mind, what lawyers call mens rea, to be found guilty of a crime.
That makes intuitive sense, right? Like there's a big difference between accidentally bumping into someone and deliberately shoving them.
Absolutely. Intent matters.
Yeah.
And the court pointed to its own past decisions to back this up. You mentioned Morissette earlier.
Yeah, the guy with the shell casings.
Right. He thought they were abandoned scrap. The court said it wasn't enough that he knew he was taking them. He had to know someone else still owned them for it to be a crime.
So knowing the facts that make the action illegal.
Exactly. And similarly, in another case, excitement video involving child pornography, the court said the defendant had to know the performers were minors, not just that they were distributing, explicit material. The defendant's awareness of the crucial wrongful element is key.
Okay, so how did they apply that principle back to Elonis and the threat statute, Section 875C?
Well, the majority said the crucial element separating legal innocence from wrongful conduct in this law is the threatening nature of the communication itself.
Makes sense.
Therefore, the mental state requirement the mens rea have to apply to the defendant knowing that their communication contains a threat. So what Elonis thinks about whether his words are threatening does matter.
So did they say exactly what level of intent is required? Purpose? Knowledge?
They clarified it would be satisfied if the defendant sent the message for the purpose of issuing a threat, or ADAR, with knowledge that the communication will be viewed as a threat. That definitely shifts the focus away from just how it looks to an outsider and towards the defendant's actual state of mind regarding the threat.
Okay, but here's where it gets a bit tricky, right? The majority opinion kind of kicked the can down the road on one point.
Yeah, that caused some disagreement. The prosecution had argued that maybe recklessness should be enough, meaning maybe Elonis didn't intend to threaten, but he knew there was a substantial risk. His words would be seen as threatening, and he posted them anyway.
So consciously disregarding a known risk.
Right. But Chief Justice Roberts specifically chose not to decide whether recklessness was enough to count as a true threat under this law. He basically said, let the lower courts figure that out first.
Why did he do that?
He called it the usual practice, letting lower courts gather more facts and hash out the legal arguments before the Supreme Court makes a final ruling on a specific standard like recklessness.
Okay, so let's recap the key takeaways from Roberts and the majority for everyone listening.
Sure. So first, a true threat conviction under this federal law needs more than just proving negligence or that a reasonable person would feel threatened. That objective standard isn't enough by itself.
Got it. More than just negligence.
Second, the big question of whether recklessness is sufficient is still officially undecided by the Supreme Court. It's sort of in limbo, left for lower courts for now.
Okay, uncertainty there.
Third, the immediate effect was that, well, your Facebook friends can't just automatically get you convicted for posts you didn't actually intend as threats.
Some breathing room for online speech, maybe?
Potentially. And finally, the majority did say that if you send something intending it as a threat, or knowing it will be seen as one, that definitely meets the mental state requirement. Purpose or knowledge is enough.
So it was a win for Elonis in the sense that his conviction was overturned because the jury used the wrong standard. But it left this big question mark about recklessness.
Exactly. And Justice Samuel Alito, in his dissent, was not happy about that ambiguity at all.
Yeah, tell us about Alito's perspective. He disagreed pretty strongly, right?
He really did. Justice Alito basically argued that the majority's refusal to just decide the standard, especially regarding recklessness, was a big mistake. He said it would cause confusion and serious problems for lawyers and judges, leaving them just guessing what mental state is actually required.
He wanted clarity. And did he think recklessness should be enough?
Yes, absolutely. He agreed with Roberts that you need a mens rea, a guilty mind, and that mere negligence isn't enough for a serious crime like making threats.
Okay, so they agreed on that part.
Right. But Alito argued that once you rule out negligence, the next logical step up is recklessness. Remember, that's consciously disregarding a known risk. He felt there was no reason to demand an even higher standard, like purpose or knowledge, especially when Congress didn't explicitly write that into the law.
He thought demanding purpose or knowledge was basically rewriting the law.
Pretty much. He said it crossed the line from interpreting the law to amending it. And his point was, someone who acts recklessly, who knows their words, might be seen as a threat, but says them anyway. They understand they're not doing something innocent. They are aware of the potential harm.
That's a powerful counterargument. What did Alito say about Elonis's specific claims, like the artistic expression defense?
He tackled that head-on. He started by firmly stating, again, that true threats are not protected by the First Amendment, period. He said they cause real harm and have basically zero social value. And he directly addressed the idea that Elonis's posts were just therapeutic or art, like rap lyrics. Alito's response was essentially, the speaker's motive for therapy doesn't cancel out the harm caused to the victim.
The impact matters regardless of the artist's intent.
Exactly. And for Alito, context was everything. He made a really sharp distinction. He said, look, Rap lyrics performed for an audience. People are unlikely to interpret those as a real threat to a real person.
Right, in different contexts.
But, he argued, statements on social media that are pointedly directed at their victims, like Elonis's posts were, are much more likely to be taken seriously. He warned that just putting a fig leaf of artistic expression over a threat doesn't make it protected speech.
He worried it would create a loophole.
Yeah, he said it would give a license to anyone who is clever enough to dress up a real threat in the guise of rap lyrics, a parody, or something similar. And he pointed to the very real fear Elonis's wife experienced as clear proof of the harm these kinds of threats cause.
So, two very different views on where to draw the line, even though they started from some similar places.
Absolutely. It's important to see where they actually agreed to.
Yeah, what was the common ground?
Well, both Chief Justice Roberts and Justice Alito seemed concerned about judges overstepping, legislating from the bench. They both prefer letting elected officials make policy.
Okay, respect for separation of powers.
Right. And they both agreed that the actual text of the law, 18 U.S.C. Section 875C, doesn't explicitly say intent to threaten. They acknowledged that if Congress had wanted that specific standard, they probably would have put it in writing.
And they both agreed negligence wasn't enough.
Right. Correct. Both sides agreed that just being careless or unreasonable isn't sufficient grounds for a criminal conviction for making a threat. You need something more than negligence.
But the core disagreement really boiled down to what that something more is when the law itself is silent on the exact mental state.
Precisely. Alito was worried that if you require proof of subjective intent to threaten, guilty people could just wiggle out by claiming, oh, I didn't know that was illegal, or I didn't mean it that way. He thought the reasonable person standard, or at least recklessness, acted as a necessary backstop.
Preventing people from just playing dumb about the impact of their words.
Kind of, yeah. Whereas Robert's main concern seemed to be protecting potentially innocent people from being convicted based solely on how others perceived their words, without considering their actual mental state. Relying only on that objective, reasonable person standard felt too close to punishing negligence, which the court generally avoids in criminal law. He focused on ensuring a truly guilty mind.
So the Elonis decision threw out his conviction because the jury got the wrong instructions.
Right. They were told the reasonable person standard was enough, and the Supreme Court said, no, it's not.
But it deliberately left this big question hanging. Is recklessness enough? Or do you need purpose or knowledge?
Exactly. It clarified what the standard isn't. It isn't just negligence or objective perception, but it didn't definitively say what it is, beyond purpose or knowledge being sufficient.
So that leaves the door wide open for lower courts to battle this out, and maybe even for the Supreme Court to revisit it down the line.
Absolutely. It's a perfect example of how the law often has to play catch-up with technology and society.
Yeah.
It's usually a slow, step-by-step process, figuring out how old principles apply to new situations, like threats made with keyboards instead of fists or voices. They're still grappling with how to pin down intent online.
So if we boil it down, what's the big aha moment for you listening? Elonis v. United States really did shift the focus, didn't it? It moved away from just asking, how would a reasonable person see this post? Towards what was the speaker actually thinking, at least to some extent.
Definitely. It rejected that simple objective test for criminal liability under this statute.
But crucially, by not deciding on recklessness, it created this kind of legal gray area, maybe even a tightrope, for online speech. It means we're all still kind of wrestling with this fundamental tension between personal responsibility for our words and how those words might be perceived as threats in the digital town square.
Yeah, it's not just some abstract legal argument. It has real-world consequences for how you, me, everyone expresses themselves online. It highlights that constant push and pull between free speech, being responsible for what you say, and the undeniable harm words can inflict, especially online, where intent is just so easy to misread.
Understanding these different viewpoints, the majority and the dissent, helps us all be a bit more thoughtful online, hopefully.
Hopefully, it's a crucial context for navigating the digital world safely and, responsibly.
So that leaves us with a final thought to chew on. As we spend more and more time in these digital spaces, where does the ultimate responsibility lie for figuring out intent? Is it all on the speaker to make absolutely sure their words can't possibly be taken the wrong way?
Or do we, as readers and listeners online, also have a responsibility to pause, consider the context, try to understand the intent, even when it's maybe ambiguous or unclear?
It's definitely something worth thinking about next time you're scrolling through your own feed.